Morning. Counsel, if you are not on the first case, please turn off your camera and microphone.
Oh, geez. Okay, sorry.
It looks like I still have one more attorney that's taking a moment to join. So as soon as he joins, I will go ahead and do the court cry.
Yeah.
Mr. Engel, would you mind just turning off your camera and your microphone for me until your case is called for argument, please? Thank you. Thank you. All right, so we have everyone. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning, everyone. We have 5 oral arguments scheduled for this morning. We'll take a break at some point, probably after the 3rd case. Short break, not more than 10 minutes, I would guess. And guess we're ready to proceed. I should mention one thing, just for future purposes. 28J letters are not to be submitted the day before or even a week before term of court with cases that were decided years ago. If there's something that just comes up, a new authority, the 4th Circuit decides the issue, then that's appropriate for 28J letter. But please check your rule and don't be sending us new authority that could have been offered in your brief. We'll begin with 19-1384 Weiss versus Banner Health. Mr. Bulger, you may proceed.
Good morning, Your Honors. My distinguished colleague, Mr. Hurdy. If it pleases the court, I'm here to present argument on behalf of the appellant and cross appellee in this matter, Ms. Jennifer Weiss. Ms. Weiss is one of our brave first responders, a former nurse employed at Banner Health, who filed suit against Banner for the improper denial of medical benefits. It is, I believe, agreed upon between the parties, and as the district court found, the medical benefits at issue were provided through an employer-sponsored benefit plan and is therefore governed by the Employee Retirement Income Security Act of 1974, commonly referred to as ERISA. In this particular case, Your Honors, the medical procedure in dispute is referred to throughout the briefing as an ACI, which is an autologous chondrocyte implantation. The procedure was described by Dr. James Court, a Banner-employed orthopedic surgeon who conducted the first medical review of this claim on Banner's behalf. As described by Dr. Court, the ACI is a well-established surgical procedure used to treat certain types of knee injuries. To quote Dr. Court, it is supported by several well-accepted published peer review articles of improved functions and outcomes. And Dr. Court's report can be found in the Appellant's appendix at volume 2, beginning at 495. Dr. Court confirmed specifically that the procedure is not experimental. It's part of mainstream in orthopedic surgery. It is well-respected and performed by well-respected facilities throughout the country and has been proven effective on peer-reviewed articles. The issues in this case, however, go beyond simply
Let me
this.
ask you about what you mean by effective. Because I thought the data indicated that it often had to be repeated. There were adverse effects of the surgery. It often didn't help that much. What's your standard for effectiveness? Can you give any objective criteria for determining what it means to be effective in your view?
Well, based on Dr. Court's report, he indicated that the peer-reviewed medical literature did show that it was effective to treat the condition, although certainly not by any means foolproof. As with any medical procedure, there are risks, there are possible complications, but nonetheless, per Dr. Court, an accepted procedure. I believe the second medical exam cannot identify the reviewer, as he's not actually identified in the record, did acknowledge the same, including that several well-accepted recent published peer review articles in a case series of improved function and improved outcomes following the ACI procedure. And he recognizes in the studies that he noted in his report that certainly in terms of short and midterm studies do support the efficacy of the procedure.
Do you agree, counsel, that the administrator in this case has discretion given to him by the plan?
Yes, Your Honor. The summary plan description does indeed contain broad discretionary language, and consistent with this court's recent holding in the Lynn M. Primera insurance case, was provided, notice of that was provided to plan members like Ms. Weiss. We therefore acknowledge that the arbitrary and capricious standard of review applies.
Well,
Can I ask you one real quick question before we leave the effectiveness of treatment area? Does it matter in considering what is sufficiently effective treatment, whether there are other treatment options? Because I know in the denial letter here, it said, please continue to follow up with Dr. Gersoff for other options, but she's too young for a knee replacement surgery. And I'm not sure there's any other available option. Does that matter as far as measuring effectiveness?
Certainly matters to Ms. Weiss, Your Honor. I believe Dr. Court echoed that sentiment that based on the standards and protocols for the procedure, she would meet all accepted criteria. In terms of
well, let me follow up, because Judge Phillips makes an important point, but also included would be how effective it is. And when you say peer reviewed, are they just one surgeon reporting that surgeon's results and that surgeon's evaluation, or are these other types of studies? And the figure that I found most remarkable as a negative is quoted on page 7 of the insurer's brief. And it says, a review of the surgery, quote, found an overall failure, I'll paraphrase, an overall failure rate of 5.8%, reoperation rate of 33%, with 90% of studies being scored as poor.
What, Judge Hartz, I'm sorry.
Yes. I'm sorry, what'd you?
You were so far away from your mic that I couldn't hear what you just said.
Oh, you're probably lucky. I leaned over to read. This is from page 7 of the appellee's brief. There's some bullet points, and I'll paraphrase the last one, but I think paraphrase accurately, that a review of the surgery found an overall failure rate of 5.8%, a reoperation rate of 33%, with 90% of studies being scored as poor. Now, what is your response to that data, to those data?
And I believe the data that you're referring to, Your Honor, comes directly from the edition, I believe from 2011 of the Macmillan Care Guidelines that ultimately Banner used as dispositive evidence of whether or not the procedure was effective or not, or medically necessary to track the language of the plan. What's absent from the record, from Banner's analysis or from the district court's analysis, is any attempt by the medical reviewer or by Banner as the administrator of the plan to distinguish between that data that you've cited and the other data recognized by Dr. Court and submitted by Dr. Gershoff that found the procedure was indeed effective. One of the cornerstones of ERISA is that it requires principled, reasoned decision-making without any attempt whatsoever to reconcile the differing opinions. It could not satisfy the standard for an arbitrary and capricious standard of review.
How would you suggest that a judge looking at two different approaches, both of which some people agreed was good, and one is chosen, should have done something different when there's discretion given to the administrator?
Yes, Your Honor. Under the arbitrary and capricious standard of review, the court's task today is not to determine what would be the best outcome, but the court's task is to decide whether or not the record reflects that there was substantial evidence to support the ultimate decision, and whether it was rational or not. And what we don't have in this record is any actual.
If
Yes,
somebody said, reads the statistics that Judge Hart's read from the MCG, which is a very well recognized research tool, and comes up with a decision, how can that be wrong?
Well, it can be arbitrary and capricious, Your Honor, when instead of applying.
Capricious if two people say it's good and two people say it's bad, the arbitrator or the administrator can legitimately choose one or the other, can he not?
An administrator can apply the language of the plan, and the plan language in this case specifies that they will examine medical records, protocols, and authoritative medical literature.
Okay.
What happened in practice, for all practical purposes in this case, much as what happened in the Lynn M case, is that the administrator directed the second medical review to apply the Macmillan Care Guidelines as a dispositive standard under this plan. And that is contrary to the plan language, which does not indicate or reference anywhere that the Macmillan Care Guidelines are the dispositive standard for review or determination of medical necessity under this particular plan. One needs only look at the three separate decisions made in this case. The first two specifically and provided the only rationale that we rely on the Macmillan Care Guidelines to make medical decisions, to the extent that they ignored the opinion of their own mandatory medical review dictated by ERISA. The denial letter mentions that a medical review was done and then simply disregards without discussion the results of that review, instead saying we apply the Macmillan Care Guidelines.
So
okay. Go ahead. Sorry.
Is it arbitrary and capricious then unless the administrator refutes all of the competing views? Because certainly the Medical Review Institute acknowledged that there were those other views. And does it really need to go through and dispute them point by point, Dr. Gersoff or any others?
I think what ERISA requires, Your Honor, is at least a rational discussion of the competing views and why one was chosen over the other, which is absent from this record. There's essentially an acknowledgement of the contrary conclusion and then no discussion as to why the data from the MCPN or from the Macmillan Care Guidelines was being utilized in lieu of the other peer-reviewed authoritative materials that were submitted by the first IME, who concluded this was a effective, non-experimental and established procedure, and Dr. Gersoff, who also advocated that position, again providing underlying medical literature.
But there can be differences between literature, and maybe it would be helpful to understand better. Perhaps I have a misconception of what the MCG does. There will be lots of reports. A surgeon will say, I did this and I got great results, and that'll be published. That's important for people to know. But then some other institution, and I gather this is what the MCG does, but I may be wrong, it goes through all the literature and looks at all the studies that have been performed and says, some people report good results, but when we look at the data overall, we get these results. And wouldn't that be a much more reliable source than that of an individual surgeon reporting that surgeon's results?
Well, Your Honor, based on the record that's available, it's very difficult to tell exactly what the Macmillan Care Guidelines are. There's no reference to it in any policy manual. The full guidelines are not even included in the record. There's simply a 3-page excerpt that Banner instructed its reviewing medical physicians to apply as a standard under the plan, contrary to the actual plan language.
We don't have anything in the record to show how the MCG prepares its reports?
I don't believe, other than the 3 or 4 pages specific to the ACI, there's any other additional materials about the Macmillan Care Guidelines included in the record.
Thank you.
As there is another significant issue that must be addressed, Your Honors, in terms of the statute of limitations, with the court's permission, I'd like to leave my brief remaining time for rebuttal.
Thank you, counsel. Mr. Hardy.
May it please this court. There are 2 issues presented for review today. First, this court should affirm the decision of the district court determining that Banner Health properly decided that its health and welfare benefit plan did not provide coverage for Ms. Weiss's claim for autologous chondrocyte implantation, or ACI. And second, this court should reverse the district court opinion that the 1-year limitations provision in the plan did not bar Ms. Weiss's lawsuit, which was filed nearly 2 years after her final decision on appeal. I address each of these issues in turn. As to the first issue, Ms. Weiss on appeal essentially makes 2 arguments. One, that Banner Health could not rely on the Milliman Care Guidelines in determining that the ACI procedure did not meet the definition of medically necessary as defined under the plan. And 2, even if Banner could rely on Milliman, it failed to consider other evidence submitted with her claim, and therefore acted arbitrarily and capricious in denying it. This court should reject both arguments. First, the plan does not limit the type of information Banner can review when deciding whether a procedure meets the definition of medically necessary. While the plan does not refer specifically to Milliman, it states that the list of potential resources is not exclusive. While Ms. Weiss is critical of Milliman, objectively, it is well recognized in the healthcare industry as providing evidence-based criteria for determining the medical necessity of procedures.
Well, let me ask you about that.
Oh, go ahead, please.
No, I think, go ahead, Judge Phillips.
All right. My concern that perhaps you could address is not with Milliman so much as Banner picking and choosing, depending on every case that comes through and different conditions, what's medically necessary, and say the next case involves a different condition, and Milliman suggests that it's effective treatment. Can Banner just ignore Milliman for that one and go find a different group that says it's ineffective? Do you see what I'm saying? Can it just hop around until it finds someone who agrees with it, deny coverage, especially when there's a conflict of interest?
Yes, Your Honor. Well, I think it's interesting that Banner is in the healthcare industry. It runs hospitals and employs doctors, so I think it's particularly appropriate that it's relying on Milliman as this industry standard. And if you look at the guideline itself, I mean, it cites several references. I think there was some colloquy in the initial discussion about, you know, what is Milliman based upon, but there are several endnotes, I believe more than 20, in terms of how it compiles or reviews literature to compile the information therein.
That's in the record? Those endnotes?
Yes.
How it gives them,
Yes. That, Your Honor, is in the record. The Milliman Care Guidelines at issue are at the record 372 through 375, and those endnotes are listed starting at 373.
And those show that it does sort of a meta-analysis. Is that right?
There are several references. I'm looking at the guidelines. There are 20 references. And again, I think there was some questioning initially about how it is compiled, and it references the literature that brings it to the decision or the compilation of information set forth in the guideline itself.
Okay, but now returning to Judge Phillips' question, is there something that should give us comfort that Banner is not being arbitrary in when it refers to the Milliman guidelines, because it only refers to it when it forbids coverage? Is there?
Well, I hope I'm addressing the question. It's recognized, it's generally recognized in the industry. I don't think there's any evidence here of cherry picking where it uses it sometimes, but not other times. There's no evidence of that. There was no discovery sought to explore that issue. The only evidence in the record is that that's what Banner relies upon. Notably, there are many cases around the country, as referenced by the district court, that find Milliman appropriate to rely upon in these situations. Also of note is that Milliman is particularly applicable here because the issue is not whether Ms. Weiss should be allowed to have this surgery because of her condition. It's the procedure itself, whether the efficacy of the procedure and whether it is well recognized. And that makes Milliman particularly established in terms of that more objective question, whether it applies specifically to her. So I think Milliman was appropriate in this regard. The second issue brought up by Ms. Weiss is to address that is that Banner did not exclusively rely on Milliman to the exclusion of other evidence submitted with the claim. And this is established by the record and particularly the external review that was performed. Now, Ms. Weiss argues that Banner ignored its own doctor's opinion, who believed that the claim should be approved from, quote, an orthopedic standpoint, end quote. However, it did not ignore this opinion. Instead, Banner ultimately disagreed with it, given several caveats expressed in Dr. Court's report, including that he had never performed the procedure, cartilage procedures had variable results, and he could not address the terms of the plan because he had not reviewed them and felt it was outside his area of expertise. He even cautioned that Ms. Weiss should have to be informed and educated regarding the variable results and risks associated with the ACI procedure. Nothing in the plan stated that Banner had to merely take Dr. Court's orthopedic opinion and ignore his other statements or other information available, including the plan language and Milliman, in making its decision. The external review also establishes that all evidence was considered in ultimately denying the claim. The external review physician was supplied with the full file, including Dr. Court's letter. The physician stated that the proposed ACI procedure was not medically necessary based on both Milliman and the plan language. In the external review letter, the doctor summarized Ms. Weiss's medical records and history. The letter referenced the plan's definition of medically necessary and specifically determined that the criteria that the procedure be, quote, medically proven to be effective treatment of the condition, end quote, was not satisfied based upon the lack of studies and published peer review literature. The letter also cited several additional medical literature references in support of the decision. And based upon this, and as examined by the district court, the record simply does not support Ms. Weiss's argument that Banner only relied on Milliman and ignored all other evidence. As to the second issue for review on appeal, this court need only reach the contractual limitations matter if it does not affirm the district court on the first issue on appeal. The plan clearly contains a 1-year contractual limitations period to file a lawsuit.
Isn't that for internal appeals? And doesn't the SPD specifically explain the participant's right to bring a civil action under ERISA would be explained and the time would be explained? And they didn't do that.
Your Honor, the plan states that and I'm paraphrasing, the participant may bring a legal action only if the action is commenced within 1 year after a final decision on appeal is made.
Did Banner send a letter denying the claim and stating in the letter, as they suggested they would do in the SPD, that there was a 1-year limitation?
No, it did not.
Thank you.
That only applies, Your Honor, to the summary plan description, as you pointed out, to the first level appeal. It does have that requirement that Banner should put that time limitation in the letter, and it did not. However, that limitation does not apply to the external review.
Where does it say that?
I'm sorry, Your Honor?
Where does it specifically state that any limitation does not apply if we deny the benefit on the final review?
So if you go to the summary plan description, there is a separate section for external review. And in that section, it states what that review letter should contain. And therein, Your Honor, there is no reference to the 1-year contractual limitations.
That's right, and that's why you're supposed to give the insured notice in the letter denying the claim.
Well, Your Honor,
What's our rule on interpreting insurance contracts? In favor of the company or in favor of the insured in the event of ambiguity?
Well, this isn't an insurance contract, Your Honor. It's non-insured benefits. It's self-funded plan. So I don't believe that insurance interpretation would apply to this situation. However, again, there's a distinction between what the plan requires in terms of when the 1-year period begins to run, again, from a final decision on appeal, versus what the summary plan description requires, which is notice of that as to the first level appeal, but not as to the external review.
And that's stated in a letter that you sent to the insured or to the Ms. Weiss.
The external letter complies with the requirements set forth in the summary plan description. It did not have to state the 1-year contractual period.
And that's because it was dealing with, the 1 year was dealing with internal issues?
The 1-year statute, the 1-year limitation applies to the entire final process. So it's 1 year from the external review date. However, the external review letter did not have to mention that contractual limitations period.
Why not just do it? Instead of coming into court and rolling us through all of this, it's not an ink expenditure. You can do it in probably 1 sentence. Why should we encourage more of this instead of just saying, tell them?
Well, it's in the plan document, Your Honor, and certainly in terms of the first level review, it was not in that letter, but that requirement does not apply to the external review. And also,
does it say that in the SPD? Does it say specifically, this does not apply to the external review? You're on your own.
It does not state that negative, Your Honor, but it does list the requirements of what the external review letter should include, and it does not list the contractual limitations.
Right.
I hope you're getting a message. You know, if you talk to your people, just include that language in the future.
Yes, Your Honor.
Don't. It's fair. It's fair. Might as well do it.
Well, Your Honor,
we'll see what effect it has in this case, but for future work, it's just not fair.
Well, Your Honor, that brings us to the Code of Federal Regulations, and that tells what plan administrators should put in their denial letters and not. And there was discussion in the briefing about the 503-1G and whether that requires putting in a letter the contractual limitations period. Well, that applies to initial denials, not denials on appeal. And that's this court's decision in the Hancock versus MetLife case that recognized that distinction.
Okay. You're making a legal argument saying you don't have to under the CFR. You can do more than what you have to, and we'll decide whether you had to, perhaps in this case. But okay, your time has expired. Mr. Bolger, you have a minute left, I think, something like that. 52 seconds.
Thank you, Your Honor. To cut to the chase, so to speak, in terms of the statute of limitations argument, in 5 separate briefs now, the banner has focused on, well, at what phase of the proceeding does this notice have to be given per the terms of the summary plan description? Absent from the record, and what Judge Daniels specifically found, was that there is no letter at any stage, the original denial, after the or before the external review, or in the final denial, that ever mentions the limitation period. So no notice was given, regardless of what phase of the process Banner now argues it should have been given. It simply wasn't. Turning to the merits, Your Honor, Judge Phillips, I believe you hit on the primary theme, the big issue in this case. There is no evidence that Banner uses this Macmillan Care Guidelines as a matter of policy or standard. It's not referenced in the policy. There is no claim manual, not in the summary plan description of the plan language. They're free to pick and choose when they want to use it. Thank you, Your Honor.
Okay, thank you, counsel. Case is submitted, counsel are excused. And we'll turn to our next case today, United States versus Maldonado-Passage, 20-6010. Mr. Sample, are you ready to begin?
Yes, Your Honors. Good morning. May it please the court, Brandon Sample for Joseph Maldonado-Passage. Your Honors, today I want to focus my argument on the sentencing issue that has been raised in the brief in this case. The district court found that the counts 1 and 2, which involved an alleged plot to kill Carol Baskin, should not be grouped together. The district court determined that the counts should not be grouped because, as the government had advanced, they involved different, distinct kinds of harm, fear, etc., different dates, different proposed hitmen. And we believe that the district court erred in reaching that determination, principally based upon this court's decision in United States versus Norman. This is a case that was decided in 1991, I believe based upon the 1988 version of the guidelines, which application note 4 of 3D 1.2 does appear to mirror the current version of the guidelines that Mr. Maldonado-Passage was sentenced based upon. And this court rejected almost a very similar argument advanced by the government of distinct separate dates, fear, and risk of harm to avoid the grouping of counts that involved threats towards a person who was going to be flying on an airplane. The defendant in that case had tried to essentially make bomb threats while the primary victim was going to be flying on the airline, involved different timelines, and this court rejected the government's effort to have the different counts separately, not grouped. And we believe that based on Norman, that the facts of this case are essentially on all fours.
Is Norman distinguishable in that the harm that would have been suffered there would have been inconvenience? The victim would have been patted down and luggage would have been searched. Apologies would have been made and he's back on the airplane flying somewhere. Whereas the victim here was faced with the real prospect of losing her life. And is that more akin to note 4, the last example, that they do not group if convicted of 2 counts of rape for raping the same person on different days?
I don't believe so, and I say that largely based upon what Norman had adopted in reference to the Sixth Circuit's case in United States versus Wilson. In Norman, they talked about Wilson was a hitman case, kind of like the facts at issue in the Maldonado-Passage case. And Norman said that the defendant had been making phone calls where he was trying to get a hitman, and the court used the rationale from Wilson to further support its determination that under those circumstances the counts should be grouped and not separate. So I don't believe the fact that the nature of the possible harm is sufficient to bring it within the exception that Your Honor referenced in note 4.
Let me ask you what our standard of review is here. There appear to be at least 2 lines of authority in this circuit regarding the application of a guideline to essentially undisputed historical facts. One line says our review is de novo. Another says the test is clearly erroneous. Perhaps if we look further, we'd see cases that say it's abuse of discretion review. I'm confident which type of review you would prefer here. Can you make sense of our precedent and tell us why your view of the standard of review is correct?
Your Honor, of course, we would advance that the court should review the issue de novo. I believe that in large part, for the purposes of this case, it's really turning on an issue of a legal determination as applies to the facts. So it's almost like a mixed question of law and fact. And in other contexts, for example, like in the ineffective assistance of counsel context, where you have mixed questions of law and fact, this court typically will review those issues de novo. And I think that it would be appropriate, particularly when the court is having to make a legal determination about the legal applicability of the relevant guideline provision to these particular facts, that it should do that de novo.
But am I correct that the ultimate decision here is whether this was the same course of conduct? Isn't that essentially it?
That is true, Your Honor. Yes.
And haven't we on occasion said that that's a factual question reviewed for clear error? And to take it one step further, the purpose of this guideline is to control abuse of discretion by prosecutors in overcharging. And that ultimate decision strikes me as one that district judges who are familiar with how things are charged and so on is in a better position than appellate judges who probably don't have a lot to offer here regarding whether for that purpose, for the purpose of preventing overcharging, the determination of whether it's the same course of conduct is best left in the hands of the district judge? Can you respond to that? It's a tough question. I'm not expecting a definitive answer, but
it is tough, Your Honor. I appreciate the court's institutional concern for the role district courts play in these types of fact-finding processes, and I think though that you would almost look at the. I would want to defer to like the rule of orderliness that you typically see, that what standard review did this court apply in Norman? And my recollection of that is it reviewed it de novo. And so just based on that alone, I would argue that line, or at least Norman as applied here, which I think was the first case where we got into this kind of situation with 3D1, that the court would use the de novo standard. Digging deeper, I would love the opportunity to provide the court with some short further briefing on that particular issue, if it would be really provide, I think, an answer that Your Honor would like to receive just in the course of this argument.
How many pages do you think you'd need for that?
Probably not more than 5, Your Honor.
Well, unless another member of the panel disagrees, if counsel wants to address the standard of review in briefs not longer than 5 pages, due in 10 days, then we'll permit those simultaneous briefs. Judge Kelly, do you have some suggestion in that regard?
No, that's fine with me, but I think you ought to start with the language of the sentencing guideline, that all counts involving substantially the same harm shall be grouped together into a single group. And the commentary seems fairly clear, although it's not really very clear, that when the same victim and 2 or more transactions, a common scheme to do the same one thing to that person, you group them. I mean, put that in your 5 pages.
Yes, Your Honor. I mean, that's the argument that we've advanced, that realistically, and the parties in the district court, the district judge, they indicated this was a close call, and the district court, gave a lot of attention to this issue and trying to distinguish some out of circuit precedent that came to a different conclusion. But we do think it's rather straightforward, and if the panel doesn't have any other further questions,
I do. I have
yes, Your Honor.
Question too.
Go ahead, Judge Kelly.
What are we talking about here, whether it's grouped or not grouped, with respect to the sentencing involved? How many more months did your client get because there was no grouping, as opposed to if they had been grouped?
So the revised range, Your Honor, if I recall correctly, would have been 210 to 262 months, right, if the counts had been grouped. So right, he did receive more time than the low end. He did receive
200, and how many months did he get?
I believe it was 262, but I don't recall offhand.
264.
264.
Without grouping, it would have been 262 to 327. And he got 262, you said?
No, it would, with grouping, it would be 210 to 262, Your Honor.
Right.
Yes.
That would be the range.
Correct.
And without grouping, it's 262 to 327.
Correct.
And what did he get?
264, I believe Judge Phillips indicated.
Okay. So 2 months is what we're talking about, theoretically.
Well, Your Honor, if we assume that the district court imposes the low end, if this court was to vacate and remand for resentencing, then it's a lot more than 2 months.
Hope springs eternal.
It does, Your Honor.
My question for you concerns the language of the guideline and just what we make of this. When counts involve the same victim, check, and 2 or more acts or transactions, check, and then we get to connected by a common criminal objective, which may be killing her, or constituting part of a common scheme or plan, which is 1B 1.3 kind of language, so we have some direction in the guidelines. The examples that are given to illustrate what that means are as you noted, in application 4. And there are a number of them given which don't really seem to me to be the same as what's involved here. For instance, stealing a car and changing the odometer, I think, is one of them. Which of these 4 examples do you rely on to say, that one's like our case? And if none of them are, does that weigh heavily against your position?
Your Honor, we rely principally on the language of the guideline itself and not the examples.
I understand, and I understand why, which is I don't think any of the examples particularly help you, but the guideline commentary, unless it runs counter to the guideline itself, is treated like the guideline.
Your Honor, I of course appreciate how the application notes interact with the guideline itself, but we also don't have anything that's factually similar in there to the particular situation either. And so I think it also cuts the other way as well, that if there's nothing in the application note that's on point, the argument can also go that we should be just really focusing on the guideline itself, the plain language of the guideline.
Isn't the closest one the rape?
We would disagree, Your Honor, and we think that the Norman case is what makes plain that that's not the case. The rape exception, the rape example was already in existence at the time when this court decided Norman. It was there from the guidelines from the get-go. And if this court wanted to draw that kind of distinction, it could have done that in Norman. It could have rejected the Sixth Circuit's decision in Wilson, and it didn't do that. And I think that just based on Norman, which is our best case for reversal here, that the judgment of the district court should be reversed and the case should be remanded for resentencing. And with that, if there are no further questions, I'll reserve the balance of my.
If the counts had been split, let's say that they charged him one with crossing state lines to hire a murderer, and then the other count was an offshoot of that, but a different factual basis. Would you have the same argument?
If it's part of the same criminal objective, common scheme, or plan, I believe that our argument would likely be the same.
Okay.
Thank you, Mr. Sample. Mr. Krieger?
Thank you, Your Honor, and may it please the court, Stephen Krieger on behalf of the United States. The district court properly declined to group counts 1 and 2. I think probably the best place to start, although it sounds like the court will want supplemental briefing on this, maybe to discuss the standard of review a little bit, because I know the court was spending some time there. Ultimately, the overall grouping decision is reviewed de novo, this court has said. But under the de novo standard of review, there are subsidiary questions. One such question is the primary driver here, which is essentially whether there was the same course of conduct. And that subsidiary question, this court has said it is a factual question that's reviewed for clear error. And the reason being is the district court is then the best place to review all the facts, having been exposed to everything, having been exposed to the trial, having seen the witnesses, knowing the inner workings of the case, has an institutional advantage in determining whether it's the same course of conduct, whether it's the same harm, or whether it's divergent harms.
Why does it when none of the facts are disputed here?
Well, Your Honor, the dispute would be that this is part of the same. Here's, I think, probably the best example.
It's a legal question, whether it's the same course of conduct or whether it's the same common scheme or plan. It's made of facts. There are all sorts of facts that are resolved so that then you can apply that standard. But I don't understand why the standard itself is a fact question rather than a legal one.
Well, you know, perhaps a hypothetical that's not this case might provide some illumination. So let's say you have this case versus you have a case where Mr. Maldonado-Passage hired the second hitman to help the first hitman. And so they would be working in connection. At that point, you don't have a two-pronged attack, which is what the Seventh Circuit said in Scott. You have two different lines of essentially you have double the harm, to use the phrase that Scott used. It's that determination, were they working together? Are they not working together? Is it the same course, or is it two separate courses running parallel that are factual questions? More to the point, or in addition to that, Mr. Maldonado-Passage's attorney said that Norman provided his best support. The deal is, the problem with Norman is that when this court was addressing 3D 1.2b, the court didn't have any factual findings because the district court in that case had used a different guideline that it considered similar. And it had concluded under 3D 1.2d that they could not be grouped. This court concluded that a different guideline applied, therefore a completely different rule applied, and went on to analyze it in the first instance. Looking at Norman, there are a couple of distinguishing factors. First of all, this was, Norman essentially was we're going one course of action. The defendant called the airline, told the airline that his victim was carrying a bomb on board. But by the time that first call had happened, the victim had left. The defendant Norman called again. The victim wasn't even on the airplane. It wasn't until the third attempt that he was actually taken off the airplane. This would be akin to if the first hitman had tried and been unsuccessful, tried a second time and been unsuccessful, and then tried a third time. All three of those counts with the same hitman, the government would admit, would likely be grouped for purposes of, ultimately we wouldn't be charging three separate counts involving the same hitman, but ostensibly those would be grouped because it would be that hitman attempting to murder Ms. Baskin. Again, going back to Scott, the issue that we have here is we have one course of conduct, we have one hitman who's operating independently. We then have Mr. Maldonado-Passage attempting to hire a second hitman to double down on the risk of harm. And I think this gets into both what Judge Kelly and Judge Phillips were asking and discussing, which is the guideline itself. There is something in addition to the same victim. There has to be
harm. What was the harm that they wanted to do to the victim?
Well, in the first count, Mr. Maldonado,
killer.
Well, Judge Kelly, in the first
second one was the same, was it not? She can only be killed once.
Well, Your Honor, I think the issue I would take with defining it so broadly is that when you look at the examples the Sentencing Commission provided of things that do not group under 3D 1.2b, for example, to use the example that Judge Phillips was referring to several times, rape. The purpose of a rape, depending on who you ask, is either to derive sexual gratification.
Purpose of what? I'm sorry.
The purpose of a rape. So the guidelines specific.
Well, yeah. Two rapes, that's two separate incidents that are completed. In other words, if I beat you up tomorrow and then wait for you on the street a week later and beat you up again, I don't think you'd say that's just one offense. I'd say that's two, and they shouldn't be grouped.
Well, Your Honor, if the rape can be distinguished as far as that, I would
distinguish it really easy.
Okay. I would back the court off to a different example that the guidelines say should not be grouped, and that's the shooting of shooting at the same federal officer. And those shootings, the guidelines say, should not be grouped. The shootings in both of those instances would be essentially an incomplete act against the same victim on different occasions.
But isn't that just expressing the same thing Judge Kelly just was, which is the victim suffers that scare and that harm independently on separate occasions, which didn't happen here?
Well, Your Honor, Ms. Baskin was aware that hitman had been hired to kill her, and then was aware, I believe, that Mr. Maldonado-Passage was seeking to hire a second hitman.
Oh, I didn't understand that.
You didn't understand what I'm saying, or
no, I didn't understand that was the facts.
I believe that's accurate. I'm drawing a blank on where it would be in the record, and I apologize for that, and I could be mistaken.
Well, what do we do about comment 4? Everybody's talked about comment 3, but what about comment 4?
Well, Your Honor, comment 4 specifically gives the example that 2 robberies are not to be counted, and it gives the reason that the
Well, it says counts that are part of a single course of conduct with a single criminal objective and represent essentially one composite harm to the same victim are to be grouped together.
Correct, and this is where
even if they constitute distinct offenses occurring at different times. So I just don't know where you're going with that.
Well, this is where I would go back to the rationale the Seventh Circuit gave in Scott. Because in Scott, the Seventh Circuit explained that when you hire a second hitman, or where you attempt to hire a second hitman, where the first is still out there, that is a separate composite harm, because that is an attempt to increase the risk to the victim. And ultimately what it...
Oh, the Seventh Circuit case really was dealing with a variance, wasn't it?
It was dealing with the departure because
the dicta on with respect to the other item.
Well, Your Honor, the rationale for the district court for imposing the departure and the rationale for the Seventh Circuit in affirming the departure was because the Seventh Circuit and the district court in Scott concluded that the situation where 2 separate hitmen are hired independently of each other should not have been, or was outside of the heartland and was not envisioned by 3D 1.2b. What we have here is essentially cutting out the let's group it and then depart because the situation isn't covered by 3D 1.2b.
Well, would it be different? Excuse me, go ahead.
Please follow up.
Would it be different if she had known of the first hitman coming towards her and then he didn't make it and then she found out the second one was coming? Would that make a difference in your argument?
I don't think it would make a difference. I think it would make it stronger. The guidelines largely look at the culpability or the intent of the defendant throughout the guidelines. And so Mr. Maldonado-Passage, by not calling off the first hitman and hiring a second hitman, was attempting to increase the risk of harm to Ms. Baskin. Otherwise, what this court would be holding is that in the case of the hitman, a defendant is free to hire a second, a third, a fourth, a fifth hitman, and constantly increasing the risk to the victims with absolutely no increase in the defendant's sentence, which is ultimately what the Seventh Circuit was concerned about.
Well, if Scott controls, you would lose. If Scott were a 10th Circuit case, you'd lose because, and I'm asking this question, I don't mean to sound so assertive about it, but you would lose because the Seventh Circuit, it's the same case as this one. You have murder for hire with hitman number 1, who then gets in jail and tries to subcontract it. The woman who is trying to collect the insurance proceeds is dissatisfied with him and goes and gets her own hitman, a second one. And so it's like our case in that there are 2 separate hitmen controlled by the person equivalent to the defendant here, and the court grouped those 2. And that's our question, is whether we should group it. I understand that it then went to departure, but I don't care because that's not our question. Our question is grouping. And the Seventh Circuit grouped in our exact situation. Tell me why not.
So the Seventh Circuit did not group. The district court grouped, and that grouping decision was not appealed. And so whether or not to actually group was not before the Seventh Circuit in Scott. What was before the Seventh Circuit was the departure. What the government is relying upon on appeal, what the district court and the probation office relied upon in the district court, is the rationale in Scott. And the rationale in Scott is that the hiring of a second independent hitman increases the risk to the victim twofold, because in the application notes, in determining whether there's a common criminal objective or the same scheme or plan, one of the things that the court looks at is whether there's one composite harm or whether there's multiple composite harms, and composite harm being defined as including an increase in risk to the victim. That's what's said immediately before the parenthetical, where it explains that robbery of the same victim on 2 different days should not be grouped. Even though it doesn't say this part, but it follows, even though the objective of the robbery would be to obtain property from the victim. The common thread that runs through all 3 of the court should not group is that the 3 examples all involve the same offense and ostensibly would all involve the same criminal objective, be it shooting at a federal officer, which would involve attempting to kill them, presumably, robbery, attempting to obtain the victim's property, or rape, which would, again, depending on who you talk to, either be to exhibit power over the victim or to exact sexual gratification from the victim. In all 3 of those cases, if you define same criminal objective broadly, then you would have to group those cases. By giving these examples, the commission says you don't group it that broadly. What you do is you look at, is there a separate risk of harm? And as the 7th Circuit explained in affirming the departure, and as the district court found here, in concluding that 3D1.2b does not apply, is that by hiring a second hitman or attempting to hire a second hitman, you increase the risk, or you're intending to increase the risk to the victim more than what already exists with the hitman that's already out.
What I was talking about in Scott, and I concede your point that it is the district court that's saying that, and the 7th Circuit is acknowledging the district court's position. But in footnote 3, the 7th Circuit says that it refers to violations of section 1958 or statute, and says that 3D1.2b, the guideline that requires forming of a single group from different criminal offenses, in this case, multiple violations of section 1958. So can't say that the 7th Circuit held that, but certainly in that footnote, it's suggesting it pretty strongly.
If I remember that footnote correctly, first, can I respond? Judge Harris,
Yes.
if I remember that footnote correctly, I believe that's talking about ostensibly why the district court would have grouped it. I don't have Scott right in front of me, so I'm not 100% sure on that. If there are no further questions.
Judge Kelly, do you have a question?
Nope, I have no question.
Your time has expired.
Thank you very much.
I have nothing further, Your Honor.
Oh, okay. I was going to give you 20 minutes, but that was an excellent argument, both counsel. Thank you very much. Case is submitted. Counsel are excused. Shall we go ahead and take the 3rd, gentlemen? Judge Kelly, Judge Phillips.
I'm sorry?
Shall we go ahead with the 3rd then?
Sure.
Yeah. Okay.
You're the leader.
Well, weak leader. Next case is Bridges versus Wilson, 20-5037. Counsel ready, so give me 1 second here. Okay, Mr. Mortensen. Yes, Mr. Mortensen, you may proceed.
Yes. May it please the court, my name is Thomas Mortensen. I represent the appellant, who was the plaintiff at the district court. This is an appeal of the granting of summary judgment based on a assertion of immunity. The state law-based immunity under the Oklahoma Governmental Tort Claims Act. This court should find for the appellant and remand the matter for essentially 3 reasons. The first one being that when the court decides issues of a state grant of immunity under the Oklahoma Governmental Tort Claims Act, it should interpret it based on state substantive law. And I've cited several cases for that: Prospect, Gurich, and Smith versus Stillwater. Second reason is that the district court made certain factual findings that should have precluded summary judgment, even based on this granting of immunity. And the third reason is that the record contains evidence, at least a vast amount of factual disputes, that should have precluded summary judgment based on whether or not the officer was conducting a protective activity or a law enforcement activity. The evidence that being several statements, which I've included in my brief, that talk about how he believed he was responding to a possible crime.
Let me ask you about the first point you made. Now, you're absolutely right that state substantive law applies, but aren't we bound by 10th Circuit precedent that interprets state law absent some intervening state court decision that undercuts it? So isn't it appropriate here for us to look at prior, at least published 10th Circuit opinions?
Yes, you're absolutely, Judge. You should. However, I think that the prior decisions don't defer to the substantive law as decided by the Oklahoma Supreme Court. For example, in some of the cases cited in the Rule 28 letter by Appellee, they don't even interpret Smith versus City of Stillwater. They don't interpret State versus Gurich, which fundamentally changes the way that specific immunity is applied to the context of police actions.
And those, the Oklahoma cases you're referring to that weren't addressed predated our decision? We just missed them or ignored them?
Depending on what case that you're talking about, I think
certainly if there's an intervening Oklahoma court decision, then we would not be bound by something we had said before that Oklahoma decision, contrary to what we said in our decision. But we've got a problem if we simply misinterpret or ignore a state precedent. I think we're probably still bound by our 10th Circuit case, even though if we had looked at Oklahoma precedent predating our prior decision, we might not have come out the same way in our decision. Am I wrong about that? Or did I even make sense?
You did, Judge, and I'm afraid I have to take the position that would be wrong, that you would be bound by that prior published 10th Circuit decision if it in fact ignores state substantive law or the interpretation of this by the Oklahoma Supreme Court. It's not. I don't think it's not a battle of the decision making from the Oklahoma Supreme Court versus the 10th Circuit. It is a matter of really fundamentally the state of Oklahoma finally coming in line with the type of interpretation to that specific immunity that other states have found themselves bound to. Oklahoma was pretty unique in that we found ourselves granting immunity to an officer who the way that case law read, it could lead to very perverse results. For example, a police officer steps out of a car, sees a person that needs protection, decides to shoot at him instead, and the only thing that they need to cite to in response to our summary judgment is that they were in the act of protecting. The initial stages of protecting, that's all that a person would have to say. They don't have to provide any proof. For example, the appellee didn't provide any proof, and they certainly didn't respond to the allegations that were raised by the appellant plaintiff in the deposition testimony, where he says he's responding to a crime. Certainly these are law enforcement functions and not protective.
Well, you can have a mixed protective and police action in the same way in that school case.
Yes, yes, you could, but by definition, if you have a law enforcement activity, I think it takes it outside the scope of that immunity.
Oh, correct. Yeah.
What is the effect of the jury verdict on everything we're talking about right now? Because, and maybe just step back and describe for us what was at stake with the jury and what the jury found, and then tell us how that affects anything we're dealing with now.
Well, unfortunately, it was a general verdict. So I don't believe one could necessarily discern a great deal of.
One could discern that the jury did not believe that the deputy had acted wrongly in firing shots.
One could certainly discern that, Judge.
Isn't that the only conclusion from that?
Well, I think, though, that at the time that the decision was made to grant summary judgment for the governmental entity here, in this case, we didn't have that jury verdict to decipher, and we had a district court saying, I believe that the evidence shows, in a light most favorable to the plaintiff appellant, that this individual didn't even fire a gun at the officer.
But we have it now, and it's a big iceberg. And I want to know how we get around that iceberg, if you have a way.
Well, number one, it was a general verdict. I don't even know if it was made a part of the record it wasn't, I don't believe by me, I don't believe by the appellee either, or whether or not there are any factual findings you could discern from that. But I think that the fundamental differences between 1983 law and qualified immunity is different than what you have as far as the negligence standards that apply to the Governmental Tort Claims Act. And I think these differences really fundamentally show the difference between the types of cases that are interpreting this immunity in favor of officers, because all these cases decided by the appellee cite two cases where in every single one of them, the court found that the officer's conduct was objectively reasonable. However, in this case, the district court found that the officer's actions was not objectively reasonable at the time that that decision was made. But I understand the concern and the potential impact.
Did the court find that it wasn't objectively reasonable, or that a fact finder could have decided it wasn't objectively reasonable?
The district court found that there were certain facts when analyzed in the light most favorable to the plaintiff.
Okay. That's the important thing, because we have had cases where a district court, that's very interesting. Judge Phillips brought this up, because I can recall, I think, a case where the municipality was improperly granted summary judgment. The case went ahead against the individual, and the jury didn't get into qualified immunity, just said there was no violation. And as a result, I think, it's been a while, we decided that would be binding, kind of a issue preclusion result. And so the decision to grant summary judgment to the municipality was affirmed, because that would have had to be the result. If the case had been tried with the municipality as a defendant, the jury would have had to find in favor of the municipality, given the finding with respect to the officer. Now, you've said that there are differences in the substantive law here, because we don't know whether the jury verdict granted a defense verdict based on qualified immunity, or just that it wasn't a constitutional violation and the state law just requires negligence? Am I understanding you correctly?
Yes, the standards are fundamentally different. A bit of a stretch. I don't know how they could be analyzed in the same paragraph, really.
Well, is there a way that the jury could find that there wasn't a constitutional violation and still find that the deputy was negligent? Isn't the jury's finding that essentially the deputy had to return fire? Otherwise, they would have said that was excessive force. That's where I'm stuck right now.
Without the kind of special interrogatories that you would give to a jury where they parcel out certain facts that they specifically find, I don't know that I feel comfortable trying to speculate about what a jury might find in the confines of a jury deliberation room. I have yet to figure out any jury, whether they come back positive for me or not. I don't know what their rationale or what their thinking is. They might not have liked my tie, or they might not have liked the way that the plaintiff testified. There are so many other variables, so many other facts that without the special interrogatories to define what facts they found, I don't know that we could do so here.
I assure you our decision will not be based on your tie.
Thank you. And I would like to reserve a certain amount of time for rebuttal if I could, if there are no other questions.
I think Judge Kelly has a question. No? I guess no. Very good. Thank you, Ms. Mortensen. Mr. Miller?
May it please the court, Your Honor. There's one question here before the court, and that is whether or not Title 51 Oklahoma Statute 1556 applies to the instant case. That is an exemption from liability under the Oklahoma Governmental Tort Claims Act for acts of civil disobedience, riot, or claims resulting from civil disobedience, riot, insurrection, rebellion, or the failure to provide or the method of providing law enforcement or fire protection. Judge Frizzell at the district court properly held that that exemption did apply to the claims against defendant board, and we would ask that this court affirm Judge Frizzell's ruling. As you know, there are several Oklahoma Supreme Court cases that are relevant to this, including Schmidt v. Grady County, Salazar v. City of Oklahoma City, and they lay out the distinction that is made between when general law enforcement services are being provided versus protective services.
How about Morales versus Oklahoma City?
Sure. Well, that was
a split deal. He was protective in part, and he turned it into a police action in part.
I think the Oklahoma Supreme Court, in ruling on Morales, determined that you look at the actions of the officer vis-a-vis the individual.
Maybe it's my machine, but I can barely understand what you're saying.
Everyone, can anyone else hear me?
I can hear you.
It's not very good quality. It's not very good quality.
Very poor quality. But go ahead.
Okay. The more still you say, the more we can hear you. It's when you're doing this that I lose you.
I apologize. Morales v. City of Oklahoma City focused on a situation in which an officer was trying to break up a fight between various students.
Right.
He saw that one individual female had hit one of the other students, and in then breaking up that fight, he arrested that individual.
Well, he was assigned to the school as a safety officer, wasn't he?
Right. He was engaging in law enforcement services.
Right.
The Oklahoma Supreme Court determined that vis-a-vis the individual who he arrested, and the arrest was very key to that matter, that he was providing law enforcement services rather than protective services. Plaintiff pointed out several cases, State v. Blorich and Smith v. City of Stillwater. He maintains that those somehow changed the law. In this case, I would present that they do not. They are both cases involving police pursuits in which individuals were injured or hurt or killed during a police pursuit of a vehicle. And there was...
Just a minute, let me ask you this.
Sure.
He was originally sent out to protect somebody who was concerned, they were concerned the person was going to commit suicide, correct?
In the instant case, yes, Your Honor.
Okay. Now, how do you protect somebody, at least with a dispute of the facts, when you shoot him 13 times through the door and there's a dispute as to whether or not he had fired in the first place?
Your Honor, I would present that any disputes of fact that the district court or the 10th Circuit found are not relevant, because the question here is whether he was engaged in protective services.
Well, how can you be engaged in protective services when you're firing a gun at the person you're supposed to protect?
Your Honor, if you look at the 10th Circuit case, Samuel v. City of Broken Arrow, which Judge Frizzell found was highly persuasive, it is a similar case in which there was a domestic violence call and there was a shooting during the attempted engagement in protective services. The court found that you have to look at the subjective component of what the officer is thinking at the time and whether they believe they are engaging in protective services.
Now, that's a non-precedential case, correct?
Yes, Your Honor.
All right.
It is, also, I did present it in a 38J letter, Your Honor. Myers, the Oklahoma County.
Mr. Miller, I think perhaps the sound quality is bad because you're talking loud. Maybe this is unusual, but maybe if you talked a little softer, we'd hear you better. But in any event.
A little lower.
Yeah.
We'll be back in our courtroom soon. But let me, I'm having the same problem that Judge Kelly is.
Judge Phillips, that was preliminary to a question I had. If I may go.
Please.
Question. You said you look to the officer's subjective intent. But here we have a statement that when he was asked a residence like that, he said, a residence that you're called to where there's possibly a crime going on. And here the call was not just that he would commit suicide, but that he might hurt the caller's daughter, I think it was. So if it's enough to have a partial subjective criminal intent, why was that not satisfied here? Why isn't there sufficient evidence, at least?
Your Honor, I would maintain that if there is significant evidence that he was going out there in order to talk to the individual, that he knew the individual, that he thought he could talk to that individual and calm them down. He had significant training on how to deal with suicidal individuals. He was asked one question in his deposition of part of the reason why he had turned his lights off, and he did make the comment that you referenced, Your Honor. But if you look at the record, it also indicates that he thought he could talk to the individual, calm them down.
Let me ask you what the law is here, then. What your view of the law is.
There is.
It seems to me that his statement about possibly a crime going on is sufficient to overcome summary judgment on the issue of whether it was exclusively for protective purposes. Are you saying that even if it's not exclusively for protective purposes, you can still be protected under the statute?
I am, Your Honor. And if you look at Samuel v. City of Broken Arrow, it makes that exact point, that if there is a mixed purpose, both protective services as well as law enforcement services, that is sufficient for 1556 to apply. That's specifically mentioned in the 10th Circuit case in Samuel.
Is that consistent with Oklahoma law? Haven't the Oklahoma cases said otherwise? That if it's a mixed motive, the officer loses, or at least loses that immunity?
I don't believe so, Your Honor. I think 10th Circuit finding there is consistent with Oklahoma law. It specifically notes in that case that to do otherwise would be to eliminate the distinction between protective services and law enforcement services. And I think that is
your position is, as long as there's a reasonably well-supported claim that one of the motives of the officer is protective services, then there's immunity? Or are you saying it has to be the predominant? If it's the predominant motive is protective services, there's immunity?
I'm not sure that the case law has clarified what percentage of the motive has to be protective services. But I think if there is a mixed motive, I think that is sufficient. Though I would also say we do not concede that there is a mixed motive here. There's extensive testimony that he went out there to try to calm Mr. Bridges down, that he wanted to be able to talk to him, that he knew Mr. Bridges. There was no indication that he was trying to arrest Mr. Bridges or that he was doing anything other than engaging in protective services and trying to help Mr. Bridges based on his suicidal training, his CLEAT training on mental health, his extensive history running a home for individuals with mental health disabilities, and that's the reason he was out there. The one comment in his deposition in which he states that he was he knew that there might be a crime going out there. That doesn't mean he was going to arrest Mr. Bridges. The extensive testimony is the opposite, that he was there to try to help him and to try to calm him down.
If I may, one question. I'm the same place Judge Kelly is, which is I don't understand any of this discussion, because this is not something, we don't have a situation where we're examining what a policeman did with respect to a person, and was the policeman, by restraining this person, protecting the person, or was it arresting the person? We never get there. The deputy arrives, and whatever's in his head, I'm not sure I care, because what the deputy is doing is investigating. The deputy's trying to figure out, what do I have here? Do I have a protective services, or do I have an arrest? And never gets to that point of deciding that or learning facts that enable the deputy to determine that, because is met with gunfire. And shooting back is not a protective service. I agree with Judge Kelly on that. So help. I don't understand why. I understand all of the cases that you're citing, why that was important, but I don't know how they apply to this at all.
Well, there's a series of cases, Your Honors. I also cited several in the 28J. Hodge v. Keene out of the Western District, Myers v. Oklahoma County, Cuero v. Sulphur and Morris for a state. In several of these, they received a 911 call about a suicidal or intoxicated or both individual, and during an attempt to help those people, even if there is a claim of possibly hurting others as well, in order for something to be going on where potentially that individual could be in harm's way or other individuals, there were shootings or and this court, various district courts below you have consistently found that in those circumstances, 1556 does apply, even if they never got to the point of actually getting the person in custody, where there is a encounter of some type during an attempt to engage in those protective services and potentially get that individual into custody when various things have occurred. These courts have found that the 1556 exemption does apply. So I believe it would apply in this scenario just the same.
Would you comment on the jury verdict and whether that helps you at all? What do you think the jury verdict decided?
I believe that the jury verdict determined that Mr. Wilson did not violate Mr. Bridges' 1983, 42 U.S.C. 1983 constitutional rights.
Are you sure it didn't decide it based on qualified immunity?
I don't think that's clear from the jury's verdict one way or the other.
We don't know that it decided that. It may have said, it may have decided, was it instructed on qualified immunity?
I believe it was, Your Honor.
Well, it may have said what the officer did was negligent and may have even violated the decedent's constitutional rights, but the law wasn't clearly established at that time. That's consistent with the verdict, is in your view?
I don't believe that's in the record before Your Honor, but I do believe that is potentially consistent. That being said, as to Judge Phillips's point, the jury did not believe, it appears, the facts in the light most favorable to the plaintiff, which would be under the plaintiff's version and the version potentially found by the district court was potentially conceivable, that he just walked up and shot him through the door for no reason whatsoever. I think it is hard to square out that circle if the jury were to find that it simply wasn't clearly established, or that it was negligent but didn't meet some other standard. Under the plaintiff, so in conclusion, to the extent plaintiff is attempting to rely on Gorrich and Stillwater, these cases in no way change the underlying rules under Oklahoma Supreme Court law and under law here, which is when you look at whether or not he was engaged in protective services or general law enforcement services. You are entitled to look at his subjective mind process, and even a mixed motive is sufficient as long as he is partially engaged in protective services. That has been clear throughout his testimony, Mr. Wilson, that that's what he was engaged in. Whether or not he was negligent in the performance of those protective services is not the question here. The question is whether or not he was engaged in protective services in the first place. And I would submit that Judge Frizzell was correct on that point, and there are no disputes, in fact, that are relevant to that issue, and thus this court should find in our favor.
Thank you. Mr. Mortensen, I think you have some time, but I'd like to begin by asking you a question, if I may. Trying to understand the purpose of this statutory immunity in Oklahoma. I assume that, and tell me if I'm misunderstanding, that the statute was enacted because officers are sued, or could be sued for negligence, when they're engaged in protective services and they hurt somebody. Sometimes officers engaged in protective services do end up shooting the person. It seems to happen a lot more than it should. Maybe it shouldn't be protected, but they do. And the person who a loved one is worried about, and they call the police and say, this person's going to hurt himself, and the police come and they kill the guy. Which is very unfortunate. But I assume that the purpose of the statute is that sometimes when officers engage in protective services, they're dealing with very labile people, very upset people, maybe even suicidal people who are willing to maybe involved in suicide by cop, as they say. So these, try to get to the chase, and I'm taking more time than I hope to. These are very problematic situations, and sometimes they go terribly wrong, as happened here. Isn't this just the sort of situation that the statute was meant to protect officers from liability for? That they come to a situation where they're trying to protect somebody from himself, in this case, and that person acts in a very dangerous, self-destructive manner. Would you respond? Maybe I'm totally misunderstanding what the purpose of the statute is.
Judge, and I cases in the statute would get a jumbled mess. There may be a lot of misunderstanding. That's exactly why I believe this court really needs to set out a defining rule of law with respect to this exemption.
It would be better if the Oklahoma courts did rather than us, but go ahead.
I think that they have.
Okay.
And I think that Gurich and then Smith versus City of Stillwater fundamentally changed the landscape. Now, the purpose of the statute, as dictated by Gurich and Smith, and by the way, the Samuel versus Broken Arrow was in 2012. Smith versus City of Stillwater, which fundamentally changed the landscape, was in 2014. So Samuel was predated or was earlier than Smith. But it says that what they're talking about as far as the method of providing police protective services. They're talking about the method. They're talking about the implementation of policy. I analogize that in my brief to like a legislative function, how they vote on stuff, how they decide what their policies are going to be, and how they implement these policies. And they should not be applied to the individual officer making discretionary decisions out in the field. This statute was never supposed to apply to those individual officers. That's what Smith says. That's what Gurge says. And counsel's right. These cases had to do with car chases. But the exemption under 155.6 was not dicta. It was the main thrust. It was the main focus of these decisions and how they should be applied. In Gurge, it says the government retains immunity with respect to the formulation of policy, but is subject to liability for routine decisions and daily implementation. So the individual officer should not have been applied to this statute in the first place. And
are you saying that liability should depend on what the municipality's policy was? It sounds like you're getting into the same sort of thing as in 1983.
And I'm not talking about policy or policy decisions from the decision makers that's not what I'm talking about. What I'm talking about is those decisions are immune under the statute and should be immune because they're policy-based decisions on how their policy should be implemented out there. But it ends when the police officer leaves out the door and has to make those day-to-day decisions. That immunity does. Now, there are other immunities that apply, but not this. This is meant for the policymakers.
So when would it come up? When would it come up? If an officer goes to a home because a family member is worried about an individual being suicidal and doing very dangerous stuff. Sorry.
You're not going to buy that extra warranty.
And the person who you've come to help starts shooting at the officer, you don't think the immunity applies to the officer's response to the shooting, is that right?
That's correct. There are a milieu of other immunities that would apply in that instance, but not this particular one, not 155.6.
Because once he's responding to being shot at, it's changed from protective to criminal? Is that the reason?
No, sir. Because the way that Smith and Gurge lays it out, these exemptions were meant for the policymakers, not the individual officers who are alleged to have committed tortious acts. Not at all. Okay. It's been interpreted in so many different ways, but I think these two cases from the state of Oklahoma Supreme Court, which are, definitive, I think there's a fundamental change in the state substantive law. And as a matter of fact, Oklahoma was the last holdout with respect to interpreting it that way. And now we finally come in line with the other states that we've stolen those exemption statutes from.
I took all your time away with my questions. I don't know if the other judges have any questions, but I should give you at least a minute if you would like to respond to anything that Mr. Miller said.
Yes, Judge, I appreciate that. Counsel said that when there's a hybrid event of both police protective services and law enforcement functions, that the immunity would apply. Now, in Samuel versus City of Broken Arrow, that's not what the court held. It held that immunity did apply, but it talked about how the state Supreme Court interpreted that protection as how it was defined in this case, is restraining a subject or suspect from hurting themselves, which is a lot different from what the actions are here. Whenever you arrest, whenever you seize, not to protect that person, that turns it into a law enforcement function. And you can't have both under Oklahoma law. I believe Salazar was the defining principle behind that. But also, I think there's also a fundamental difference between when a person's taken into custody as opposed to events that happen before the person's taken into custody. Like Morales, which I've heard, it talks about how that individual that was arrested at the school, that person wasn't seeking protective services. That person wasn't seeking any police protection. Nobody was seeking any protection. That didn't come up, and it was an afterthought.
Thank you, counsel. Case is submitted. Counselor excused. And how about if we take a 10-minute break? Is that okay with the other members of the panel?
Fine.
Okay. We'll return in 10:51. Thank you.
Court is in recess for 10 minutes.
And we can just leave our machine on, right?
Yes.
Yes, I'm going to put everyone in the The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Okay, we'll resume now with number 20-6029, Smith versus Allbaugh. Mr. Pedersen, are you ready to proceed?
Yes, Your Honor.
Go ahead.
May it please the court, I'm Devin Peterson, representing appellants Joe Allbaugh and Carl Baer. During the time period relevant to this case, Mr. Allbaugh was the director of the Oklahoma Department of Corrections. Mr. Baer was the warden of the Joseph Harp Correctional Center. Director Allbaugh and Warden Baer are appealing the denial of their motion to dismiss based on qualified immunity. The various issues in this case can be broken down into the following four dispositive issues. The first three of which have to do with whether certain legal propositions have been clearly established in this circuit. The first issue is whether it is clearly established in this circuit that the Eighth Amendment requires prison officials to promulgate policies for specific medical decisions based on certain symptoms that may be presented to licensed medical professionals, or whether it's the case that prison officials may delegate those decisions to the licensed medical professionals rather than promulgating specific policies in that regard. The second clearly established question is whether it is clearly established under the Eighth Amendment that prison officials must promulgate policies and procedures outlining the specific circumstances in which a patient's medical condition renders them unable to voluntarily waive treatment, or whether prison officials can simply rely on the licensed medical professionals that they've hired to make those determinations. The third question has to do with employing physicians. It's whether it's clearly established in this circuit under the Eighth Amendment that prison officials may not employ licensed medical professionals who've had past discipline 8 to 18 years ago in this case for addiction issues, whether the Eighth Amendment forbids the employment of such medical professionals. We would suggest that there are no United States or 10th Circuit cases clearly establishing those issues. First, back to the first issue, which has to do with whether prison officials have to promulgate certain policies and procedures regarding the symptoms presented to medical professionals. The plaintiffs have alleged at paragraph 67 of their complaint that upon information and belief, the senior defendants, those are my clients, the appellants Allbaugh and Baer, the senior defendants failed to promulgate, implement, or enforce policies or procedures requiring medical staff, including defendants Hayes and Miles, those are medical professionals, they're not before the court today, to immediately inform a physician or refer an inmate to a hospital when an inmate presents complaints about difficulty breathing or acute stomach pain or showed obvious signs of medical distress, like a racing heart or other symptoms that are commonly associated with acute appendicitis, or that would require a physician, including Defendant Baylaw, to conduct an in-person examination of a critically ill patient or arrange for their immediate transfer to a facility. It's our position that it's not clearly established that the director of the Department of Corrections or the warden of a certain prison is required to have a policy that lays out all those things.
What was the policy?
The policy is not alleged in the complaint. We're here on a motion to dismiss.
I know, but I want you to tell me what the policy is.
What the actual policy is, I believe they do actually have policies that deal with certain medical conditions like chest pain or something like that. And those are policies promulgated by the medical director, not by a person in the position of my clients, who's the director of the Department of Corrections, the top person, and the warden of the prison. They don't have specific algorithmic decision trees for each kind of symptoms. They don't have one for appendicitis or for cancer, or they just don't have that level of detail. I do believe, if I recall correctly, if they still have it, they do have one on chest pain, but I'm not, that wasn't alleged in the complaint. The allegation in the complaint was simply that my clients, the senior officials, failed to promulgate such a regulation regarding acute appendicitis, or they failed to enforce a policy if they did have a policy.
Okay, let me ask you another question.
Yes, sir.
How many prisoners are there in the Joseph Harp Correctional Facility?
I do not have that information at my fingertips. I don't believe that was pled. I would be almost guessing if I told you I think it's 1,000.
It's 1,372.
13. Oh, thank you, Your Honor. Again, and back to,
this is a question of supervisory authority, isn't it? Isn't that the issue here?
It's a supervisory liability claim, certainly. I don't think there's any allegation that my defendants actually participated hands-on or made any kind of medical decisions or even knew that this was occurring. It is strictly, you're correct, it is strictly a supervisory liability case. And specifically, it's a supervisory liability case alleging unconstitutional hiring and these two policies that allegedly should have been implemented or enforced as pled in the alternative by the plaintiff appellees. The plaintiff has, neither the plaintiff appellees nor the district court cited any cases showing that would put defendants who are in the position of my clients on notice that it was beyond debate that they would be violating the Eighth Amendment if they did not put these specific policies in place. The plaintiff does not allege anywhere in the complaint that these policies caused any specific medical indifference problems or caused any specific constitutional violations. I believe they make a conclusory allegation that the conditions at Joseph Harp were bad, and they created an atmosphere of indifference, but there are no specific factual allegations. That's strictly a conclusory allegation, which under the Twombly-Iqbal standard is not sufficient to state a claim and not sufficient to, as the court puts it, unlock the doors to discovery. As for the, and let me briefly run through the relevant cases that have been relied upon by the plaintiffs and or the district court to allegedly clearly establish these rights to have these policies implemented or to not hire physicians with licensing discipline. Burke v. Regalado, that's a medical care case. We would offer to the court that case is distinguishable because that case relied on specific instances, identified recurring issues with the jail's medical care over a period of years. There are simply no such allegations here of any specific medical problems other than the conclusory allegations that I mentioned a moment ago. The next case is Heath versus Conner. That's a 10th Circuit case. It is a sexual assault case. And that case is distinguishable from this one in that in Keith, the court said that Ms. Keith's complaints referred to facts primarily from the audit report that could support a conclusion that Ms. Conner was aware of multiple incidents of unlawful sexual conduct. And it goes on to outline all these prior incidents of sexual misconduct that had occurred prior to the sexual misconduct with reference to the plaintiff in that case. So again, this case is distinguishable from that. The next case, Lopez versus Lamaster, that was a case alleging both failure to protect from attack and denial of medical care. That case is distinguishable from ours. It does not clearly establish the rights plaintiff alleges because in that case, there had been a prior attack that the sheriff knew about. Here, there's no allegation that there was any specific prior problem caused by my client's policies or failure to implement policies. On the medical aspect of the Lopez case, that's distinguishable because the sheriff himself directed the jailer by telephone not to take the plaintiff to the hospital because he was still conscious. There's no specific allegation in our case that my clients did anything hands-on or made any directions or even knew about this incident. The other case relied upon is Poor versus Glanz. In that case, it's distinguishable because Sheriff Glanz in that case, the supervisor, admitted that he was aware of a prior incident where a male nurse had been watching a juvenile female inmate in the shower of the medical unit, and he conceded that better monitoring could discourage future incidents. He was on notice of that problem, but he had not made any changes to the manner in which juvenile female inmates were supervised. That case doesn't clearly establish what the plaintiffs are attempting to allege is clearly established law in our case. And again, I'll just reiterate that the Supreme Court has repeatedly said that defining a right at a high level of generality is insufficient to put a defendant on notice, except in an obvious case, is insufficient to put a defendant on notice that what they're doing violates the right. The contours of the right have to be specifically identified in the case. In fact, the 10th Circuit has held that in a supervisory liability case that a plaintiff must identify a case where an official acting under similar circumstances as the defendants was held to have violated the Constitution. In this case, there are no such cases.
Did you plan to reserve any time for rebuttal?
Yes, I'm sorry. I'll reserve the remainder of my time unless there are questions.
Thank you. Ms. Rosenfeld?
Thank you. Good afternoon. May it please the court, Katie Rosenfeld on behalf of plaintiff appellee Christina Smith. Judge Kelly is correct. This appeal concerns a supervisory liability issue. And in this case, the district court, Judge Goodwin, issued a very thorough 22-page decision denying defendants' motion to dismiss in its entirety.
Well, why don't you tell us exactly what it is that these individuals, and one, the warden of a 1,372 member prison, should have been doing, and what the director of corrections over the entire state did or should have done to subject them to liability, as opposed to the people down on the ground.
Yes, absolutely, Judge Kelly. What the complaint alleges are a number of specific failures by these two defendants. One, the complaint alleges that defendant Allbaugh and defendant Baer were responsible for on-site medical care, and that in that capacity, they had a policy within the department and this prison of hiring incompetent unprofessional and ill-qualified providers, two of whom provided care to Mr. Joshua England, who died.
Is that because of their earlier drug problems?
Their suspensions, their discipline. Two of the four providers at issue, Your Honor,
And what was the causation in that particular instance?
the causation of how these supervisors caused these individuals to be hired, Your Honor?
No, well, one, does the warden of a 1,372 population even hire anybody individually? And
Your Honor.
two, was there anything that these individuals who were hired did that couldn't be remedied by a suit against them and against the, as opposed to individually against the warden and the Secretary of Corrections or the Director of Corrections?
So in our complaint, we specifically allege that these defendants did have responsibility for hiring on-site medical personnel, for managing and for supervising them.
And was that, was that admitted?
Well, Your Honor, a motion to dismiss was filed, and that is an important element of this case. We are at the motion to dismiss stage, and Judge Goodwin found that we had made multiple specific allegations against these two defendants. We identified 5 specific policies that they were responsible for either implementing or failure to implement. We identified a pattern within the Oklahoma Department of Corrections of hiring ill-qualified and grossly incompetent medical staff. As of 2012, apparently 1/3 of the doctors employed by the Department of Corrections had been subjected to discipline. And so for several pages in our complaint, with the allegations of which obviously must be taken well pleaded in plaintiff's favor at this stage, Judge Goodwin found that we had specifically alleged what these two defendants did at this facility, given the nature of hiring incompetent doctors, given
Let me ask about those specifics. You've got to establish deliberate indifference by the two defendants, do you not?
Correct.
And the two doctors that are involved here had been disciplined, but they were fully licensed when they were hired.
That is true, Your Honor. And the allegation
that they've been at the prison between the time they were hired and the time of the incident. Wouldn't it a matter of years?
We don't know, Your Honor, because as I mentioned, we're at the motion to dismiss stage. What we do know here is that a 21-year-old young man died because of the...
No, but that's not the issue here. Not yet. You've got to prove, you've got to allege facts showing deliberate indifference. And what is there to show that the warden and the Secretary of Corrections were on notice that these two doctors were not capable or were not performing adequately, other than a decades old, or in one case more than decades old, disciplinary? Was there anything to show that the warden or the Secretary of Corrections was aware of prior malpractice or inadequate treatment by either of the doctors?
Your Honor, there is nothing to show that yet, and that is why it's very important to note again that we are at the motion to dismiss stage, and that is specifically the cases that Judge Goodwin cited in his opinion, such as Burke versus Regalado, such as Dodds, such as Brown. These cases involving summary judgment where
you have to plead facts, counsel. And we just make a general allegation.
And Your Honor, we have pled facts at paragraphs 90 to 101 of our complaint, which do specifically set out that these defendants were responsible for improperly hiring, supervising, and retaining the defendants on staff, that they were aware that there was a number of medical providers in the state system and at Joseph Harp who were not qualified, that they were aware that there was a culture of constitutional disregard at Joseph Harp, that they were aware that the Oklahoma Department of Corrections was a sinking ship where inmates could not be...
I think under Iqbal Twombly, those are well and good, those allegations, but those are conclusory. You need to give some specifics of how they knew that. And there's nothing here. That's my concern. maybe
Judge
it's an interpretive concern, but
Judge Hart, if you look at our complaint, and this is specifically what Judge Goodwin held, we do allege specifically that defendant Allbaugh was aware of serious problems jeopardizing the health and safety of those inside Joseph Harp, and it quotes to specific statements in the public record that defendant Allbaugh had made about the inability of the Department of Corrections to provide for the prison population in a safe and humane way, and predicting that that failure was going to lead to lawsuits against the department. Now, that at the pleading stage certainly goes to defendant Allbaugh's knowledge.
That's interesting. You say it points to statements he had made publicly?
It cites to a public statement that defendant Allbaugh made, this is paragraph 100 of our complaint, where he says, if the state doesn't demonstrate that they can handle their prison population in a safe and humane way, what are inmates supposed to do? They're going to sue. And Your Honor,
that's hardly an admission that, where does it say that he was aware that it actually happened? Is that later in your life?
No,
that's I can't see you anymore. You're going down.
Oh.
Thank you.
That's a separate allegation, Your Honor, but we do allege that they were aware that they were providing grossly deficient medical care. And Your Honor, there are
what is the factual allegation that supports that? I thought you were going to give it to me. I thought you had a statement by him saying, we've been really screwing up, we're not providing care, but that's not what the quote was.
Well, so, Your Honor, the quote suggests that in the article, which is titled Weighing the Odds of a Federal Takeover of State Prisons, that there is a problem with the provision of safe and humane care. And Your Honor, respectfully, if we look at the cases where the qualified immunity is denied at a summary judgment stage, yes, we need to make out these basic allegations. But when you look at some of the decisions of this court that have granted QI at the motion to dismiss stage qualified immunity, for example, this court's decision in Brown versus Montoya, 2011 decision, there is a one-paragraph conclusory allegation that moves the court to find, as Your Honor is pointing out, that the allegations cannot be conclusory. Here, we've identified two specific medical providers and an allegation about the overall problem with the quality of doctors that are responsible to these defendants for their jobs. We've identified 5 specific policies that we allege plausibly are within the purview of these defendants to operate and to supervise. And
let me ask you about the policies.
Yes.
Do you have any specific allegations of knowledge by the warden and the secretary that the care had been faulty in these regards and the policy therefore needed to be established to prevent further harm?
We do allege, Your Honor, that they were aware of grossly deficient medical care being provided to inmates at Joseph Harp and took no steps to correct it. And Your Honor, what I would say is there the question that the decisions of this court look at is there fair notice? Do these allegations go beyond formulaic labels and conclusions? These are not formulaic allegations, because what we are saying here is that with respect to the provision of basic health care for an emergency condition at Joseph Harp, appendicitis, these defendants oversaw a system that could not provide that care. We've identified specific employees and specific policies that were at issue here and that were within their responsibility. We plead these are part of their job to ensure that inmates are receiving very basic medical care, and that they failed to allege, and they failed to carry out. And
well, there was a policy there, and you've already pled it, that there was a failure to enforce a policy requiring the nurses, et cetera, to immediately inform the facility medical provider, and that they failed to enforce a policy requiring them to immediately contact emergency surgeons. I got it on Do Not Disturb, too.
Just glad it wasn't my phone.
So there were policies, and you say that they were not enforced. Is that correct?
There's 2 policies as Judge Goodwin found in his decision, there are policies that were not enforced, and there were policies that were not in place. And these are not policies specific to any particular condition, Your Honor. These are the very basic policies regarding when does somebody have to go to the hospital? When does somebody require an in-person examination? When does somebody in a medical crisis need to get treatment? So we're not saying that in every tiny, small medical condition there needs to be a policy.
But there is a policy, a general policy in place, and whether it was enforced or not is what your suit is about.
Right. Well, Your Honor, we do allege that 2 policies were not in place at all, and that the other policies were in place but were not enforced.
So why don't you sue the governor? I mean, why didn't you just sue the whole state government?
Well,
they know just as much as the Secretary of Corrections.
You know, Your Honor, with all due respect, there definitely are cases where an individual at this level of government is not the proper defendant. And for example, there are cases where, you know, the Secretary of New Mexico Corrections is found not to be the proper person in a case about an individual incident. But in this case, at the motion to dismiss stage, where we have laid out the people involved, the policies involved.
You haven't laid out anything about what the individual did specifically with respect to what you're saying should have been done. Well, I found nothing there.
We have laid out the basis for our belief that these defendants were responsible, and that specifically is that this was their job to oversee the medical care at this system, and that the events that unfolded here, combined with the allegations about a general failure to have qualified staff on duty, and with the allegations about the nature, the conditions of the prison system, that these are adequate at this stage. Your Honor, we have vigorously pursued additional information in this case, but at the pleading stage, Judge Goodwin found that it was plausible, and that we had nudged this over the line from conceivable to plausible that these defendants failed to properly.
Don't you need some specifics? Can you just go out and file and say, well, I really thought it through, and they must not have done it because this guy had all these problems.
Well,
he did have problems. It was a terrible thing.
Well, Your Honor, I would say that at the motion to dismiss stage, in the analysis that Judge Goodwin put out, we have not put forward one paragraph as some of the cases that this court has found insufficient. We have put
ethically, I don't think a lawyer can file a complaint alleging a general problem without doing some specific investigation before filing it vis-a-vis the individuals that you've sued.
And we have done that, Your Honor, because
you didn't plead it. You didn't plead it if you did it.
Well, when we talk about Defendant Allbaugh's role in this, Your Honor, we do specifically allege that he was aware of the serious problems jeopardizing people's health and safety, and we quote to his publicly available statements on that issue.
Based on that statement, it does have nothing to do with what he did vis-a-vis this case. He's trying to remedy the problem, and you sue him for it.
Well, as the court is aware, the specific personal involvement is related to whether these supervisors implemented the policies properly, not whether they were involved in a specific case. Thank you very much.
Thank you, counsel. Mr. Peterson, I think you have a minute and a half or so.
Oh, there he is. I didn't know where you went.
I'm sorry, Your Honor. Unless there are questions, I don't have anything further. Thank you.
That's fine. Thank you, counsel. Case is submitted. Counsel are excused. I neglected to do something that'll take about 20 seconds. So I'll be back in 20 seconds and we can take our last things. 7013, Huff versus Reeves. Mr. Engel, are you ready to proceed? I know Mr. Dixon, Mr. Poe are sharing their time. As we say, every time that happens, it usually doesn't work out very well. And I'm sure it won't work out well this time, but you're welcome to try. So, Mr. Engel.
May it please the court. Your Honor, my name is Derek Engel. I represent Julie Huff, who is the appellant in this case. Summary judgment was granted against Ms. Huff and in favor of Trooper Reeves and Sheriff Ledbetter for this matter. Ms. Huff went to the Bank of Eufaula to check on her safe deposit box. While she was there, Cedric Norris entered the bank, killed the bank president, robbed the tellers, attempted to take another employee hostage. When this other employee refused, he shot her.
We are familiar with the facts.
Thank you, Your Honor. At the scene, after the vehicle had been disabled, Ms. Huff left the vehicle because she did not want to be in there when Cedric Norris came back in, and she was afraid he would kill her. And she ran into the field alone with her hands up. And as she turned, alone in the field, Cedric Norris was not around her at this point. As she turned, she was hit simultaneously in her leg and her arm. The only two law enforcement officers present at that time were Trooper Reeves, which was to her left, in front of her to her left, and Officer Torrex, which was in front of her to her right. The bullets hit her at the same time, and she went on the ground at that point. After she was already on the ground, Cedric Norris sought cover behind Ms. Huff, and according to the sheriff's deputy, was using her more or less as a human shield. While there at the scene, Trooper Reeves fired a total of 31 rounds of his .357. Officer Torrex fired 4 rounds. Deputy Hall fired 2 rounds.
Let me ask you a question, because as Judge Kelly said, we're familiar with the facts, and you've spent a fair amount of time going through facts again. Let's get to some of the nitty gritty.
There are 2 distinct.
Officer Hall is not involved in this appeal. Is that right?
That's correct. Sheriff Ledbetter is. Officer Hall is not.
So explain why Sheriff Ledbetter is responsible for anything that Agent Hall did incorrectly here.
Well, specifically, we believe that Sheriff Ledbetter is responsible for several things, not only for improper training, supervision, but also for, and I skipped over this because I got to the scene, but even the monitoring of the dispatch. There were 2 distinct frequencies which the officers were monitoring, in particular, Trooper Reeves. There was a city dispatch that Officer Torrex was on as a city officer, and then a county dispatch frequency that Deputy Hall was monitoring as the county deputy. And Trooper Reeves was going back and forth between these 2 frequencies.
Well, but the Sheriff Ledbetter is liable only if he was aware of problems and did not correct them. Is that a fair statement of what the legal standard is?
Well, I think clearly some of the policies don't address anything about hostages, don't address anything about what to do in a situation like this.
Why would he think that he needed to have policies with respect to hostages, for example?
I think
show that he was deliberately indifferent. This is a supervisory type liability. Doesn't he, unless the law is clear, and there's clearly established law that all law enforcement departments have to have policies against on how to deal with hostages. That's a possibility. I'm not aware of any cases saying that. In the absence of that sort of general rule, it's got to be something that this sheriff was aware of that required a policy to prevent unconstitutional conduct by his officers.
Well, not only hostage, because Deputy Hall denies knowing that Ms. Huff was a hostage, but moreover, in dealing with suspects, and they believed Ms. Huff was a suspect. And the policies are noticeably absent.
I don't know that helps you, but go ahead. I'm just trying to get clear what the legal standard is. And if you disagree with how I've stated the legal standard, please explain where I've gone astray.
Well, I think I'm sorry, Your Honor, I didn't mean to interrupt you. Were you finished with your question?
Yeah, so what I'm saying is unless there's clearly established law saying you always have to have these policies, doesn't there have to be some notice to Sheriff Ledbetter that in the absence of these policies, he's going to have unconstitutional misconduct by his people?
Well, I think it was clear that there was going to be problems with the inadequate policies on this situation. I don't have any specific fact that Sheriff Ledbetter was ever put on any specific notice of deficient policies. I don't have that fact. But
you don't think you need that? You think it was obvious?
Yes.
You think it's obvious that every department needs to have a policy with respect to hostages, or actually in this case, suspects?
Alleged suspects, yes.
Right. Okay.
And as the case law is clear on this, when the egregiousness of the conduct is so egregious, there doesn't have to be a specific case on point. And we believe the conduct here was that egregious.
Well, I'm not sure that's true with supervisory liability. If it's so obvious that you shouldn't do something, if it's so obvious that no officer should do it, like shooting someone in cold blood, then that might tell the supervisor, I don't need a policy on that. None of the people we hire would do anything so awful. So what makes it obvious that the officer shouldn't do it may also make it less likely that a policy is needed, wouldn't it?
Well, in this situation, Deputy Hall, if taken his word to be true, is that Norris was laying on his stomach behind Julie Huff. And he claims that, and by the way, this is after the trooper has already stated in his statement that he believed Norris was dead, that he was completely immobilized. After all that is when Deputy Hall fired his shots at a man laying on his stomach behind another alleged suspect. And he says he aimed at his rib and torso area. How he could do that with such precision around Julie Huff.
But you're showing that Hall should be liable, but he's not involved in this appeal. What is it that the sheriff should have anticipated?
Well,
that he needed a policy to say, don't shoot people who are apparently dead? Is that what the policy needed to be?
Or don't shoot through people who to get to someone who's apparently dead. Or when two people are clearly, in Ms. Huff's case, clearly unarmed,
Why was Ledbetter on notice that such a policy would be necessary? You would hope that it wouldn't be necessary, wouldn't you?
You would hope so.
Dead?
You would hope so.
Well, okay, I pursued that enough. Go ahead with your argument.
Well, again, there were two distinct shooting scenarios. The first one, as to Trooper Reeves, one of the bullets had to come from Trooper Reeves. There was only two law enforcement there at the time. Deputy Hall was not yet on the scene. So Trooper Reeves would have shot then an unarmed person alone, even if Trooper Reeves believes she was a suspect attempting to surrender. And that clearly goes against the Fourth Amendment and in many other cases. And so the court, in granting qualified immunity to Trooper Reeves, completely overlooked the first shooting scenario involving Trooper Reeves. The second of the shooting scenario, and we look at the Barrientos case, they need to be segmented. Every shot needs to be analyzed and segmented. Those shots that came at Julie Huff were still, she was now on the ground with the suspect behind her. And he was firing essentially through Ms. Huff to get to the suspect. Trooper Reeves claims that he could not see Julie Huff. That's what he claims. Then if that's the case, he doesn't get the hostage defense, the rescue of the hostage. But moreover, the video evidence from the other troopers' dash cam clearly shows that they were on level ground right next to each other. It's simply not credible that Trooper Reeves says he could not see Julie Huff when she was literally laying right next to Cedric Norris. Moreover, Dwayne Hall says he saw Julie Huff because she was right in front of Cedric Norris. He had to shoot essentially through her to get to Cedric Norris.
Were you able to trace the bullets?
I'm sorry, sir?
Were you able to have experts tell you what pistol, what bullet came out of that hit the...
We have one of the 10 wounds that Julie Huff has, one bullet remains in her, and that's in her groin area. It cannot be removed because of its proximity to her femoral artery. We did have that bullet analyzed by one of the world's preeminent ballistics person, Dr. Bennett Amalu, who was able to measure the size of the bullet and determine it to be a .350.
What did he determine?
I'm sorry?
What did he determine?
That bullet came from Trooper Reeves' gun.
Okay. Did you have any bullets that came from Torres's gun?
There was one bullet removed from Julie Huff, and it was the .40 caliber. And the only one at the scene firing a .40 caliber was Officer Torres.
Okay. And how about Hall?
Hall, his bullets must have passed through. He was firing a .45 caliber. But again, the facts are, according to his own statement, is that Norris was laying on his tummy directly behind.
Yeah, he was using her as a bench rest.
Exactly. And right behind her, literally raising his arm up over her.
But did he hit her? Do you have any evidence that Hall's bullet hit her?
Well, she was hit 10 times, but those bullets were not still in her.
37 rounds by Reed and Torres. So you don't have any evidence that actually Hall's bullet struck her.
We don't have any bullets in Ms. Huff from a .45 caliber.
Thank you.
But again, using Deputy Hall's own statement, it would have been impossible for him to hit Norris without going through Huff.
Unless he missed both of them, which wouldn't surprise me with a 45 caliber.
Yes, Your Honor. But he claims he hit Norris.
Right.
He claims that. I can read it to you.
You're down to 1 minute and 56 seconds.
I'll reserve the rest of my time.
Okay.
Thank you. Who do you have going first? Mr. Dixon first, is that correct?
Yes, Your Honor.
Okay.
May it please the court, I'm Charles Dixon. I represent Trooper Reeves in this, for purposes of this hearing today.
Let me just ask you right off the bat so it doesn't get lost. What's wrong with Mr. Engel's argument that the district court erred because the testimony from Ms. Huff, which seems like valid testimony, is that she fled the car, managed to get away from her assailant, raised her hands in the air, and was struck twice simultaneously? Why doesn't that at least get to a jury?
Well, let me first address the simultaneous. There's no evidence in the record that supports Mr. Engel's contention that they were in fact simultaneous.
Ms. Huff doesn't say that?
Her testimony repeatedly is, and when I say simultaneous, the way Mr. Engel and the appellant contend is it's at the exact same moment, meaning from two different people. There is no evidence in the record
What
that.
difference does it make?
Well, it makes a difference for at least one reason. The reason is if it's not simultaneous.
Testified, as Judge Phillips pointed out, she testified she got out, stood there with her hands over her head, and got shot. And
well,
the judge said, "Well, I'm going to grant summary judgment." This seems to me to be a clear factual issue.
Well, I would represent to you, Your Honor, that there is no factual dispute.
How can you represent that?
I'll represent to you this way.
We have the testimony. Whether you believe it or not is irrelevant.
Well, Your Honor, and let me proceed to explain to you why it's complete. The judge's determination is completely reasonable. Miss Huff didn't just testify she got out of the vehicle and then ended up in the field. She testified that Mr. Norris got out of the vehicle and fired 2 shots and then return fire started. And then so she wouldn't be killed, according to her testimony, which she believed that she was going to be killed by Mr. Norris. She got out, exited from the driver's side,
she was
ran towards the fence line, couldn't get over the fence, ran to the east away from Trooper Reeves' location, through the opening in the fence that had been made during the TVI maneuver by the vehicle she was driving, and into the field 4 or 5 feet, and then turned. The entire time that she's making those maneuvers, and the entire time, and it's Trooper Reeves' testimony is he never saw her.
I know, and that's where the factual issue comes
and the plaintiff made no effort. Your Honor, you raised the very issue. There's the ability to limit or look at trajectories of bullets, to look at where a location is, and where in relation to her body. Appellant's contention that Cedric Norris was not anywhere in the vicinity is unsupported by this record. The appellant testified she didn't know where Cedric Norris was. The only information in this record about Cedric Norris's location throughout this entire 43-second incident where the shooting's occurring comes from the law enforcement officers who put him beside the vehicle, who put him then running also into the same field.
Well, you're suggesting that the deceased shot this woman?
No, Your Honor, I'm not at all.
Are you suggesting that Deer Hunter, some other area, shot her by mistake?
What I'm suggesting is exactly what the court found, which is there's no evidence disproving Trooper Reeves' testimony.
You don't have to disprove it on some reason.
Well, yes, there is. I mean, we don't have to believe him.
Well, Your Honor,
we don't have to believe him. But let me get a fact straight. When did she say she raised her hands over her head? At what point?
Actually, she testified that she was running with her hands raised.
Okay.
But the entire time, if you look at her, there's an exhibit in the record where she locates herself in relation to the vehicle, in relation to where the various law enforcement officers are. By the way, she testified unequivocally that she never saw at any point after she exited the vehicle Trooper Reeves again. So she testified she gets out of the vehicle, she moves to the fence line.
She raises her hand, and she shot multiple times.
The factual
what we know, I think it's a very reasonable inference that while her hands were up, she was shot multiple times by Officer Reeves. And what the judge said is, there's no evidence to show that Reeves was wrong when he said he didn't see her. But she was visible.
Well, she's visible.
She was there. So why can't a jury believe that he did see her?
There's no evidence, Your Honor, that I keep coming back to this, that there's no evidence that the plaintiff put forth that she was visible from Trooper Reeves' location.
Well, the bullet struck her, so she was certainly visible from his gun.
Well, a bullet could have struck her whether or not he was intended to fire at her or whether or not it was a miss and he was firing at Cedric Norris. which is the issue in the case.
When you keep saying you keep saying there's no evidence, but they got out of different sides of the automobile, right?
At different times, yes.
And so they were not clutched together throughout this episode where she was struck as they were trying to hit him, even though her hands were in the air.
Well, but Cedric Norris's location is an important factor as to whether or not he's being fired at or whether or not Mrs. Huff's being fired at.
Well, let me ask you, if you take her testimony, which is that she ran away from the other direction, which makes sense, right? She's been assaulted and kidnapped and every other thing, and she has her hands in the air. Do you say at that point, if Norris wasn't right next to her, that it was okay for the police officers to shoot her?
Now, let me make sure I understand your question. You're assuming that Norris was not in her vicinity as
I'm saying he wasn't right next to her, yes. That if we assume that fact, and we know they got out of different sides of the car.
Well, they ran in the same direction.
Okay, well, let's do it this way.
Yes,
Assume that Norris is not standing right next to her or right behind her, and that she has her hands in the air, and the officer says, you look like a bank robber, Timmy. Bam, bam. Is that okay with you?
That he shot someone who was standing there with their hands raised? Yes. And based on...
It doesn't matter if she was a bank robber at that point, right? Can't shoot someone with their hands raised, unless you think you can.
I don't know that I can blanket agree that you can't shoot someone with their hands raised. They could have something in their hands. She didn't hear, but if all the facts are, and by the way, the record is will be before the court, and the video that Appellant's counsel mentioned wasn't even, it was taken from a completely different angle, from a completely different location, and would have shown a completely different perspective. There's no video, there's no evidence presented by the plaintiff of what Trooper Reeves' perspective was. They don't have to be the same. Just because from one video angle you can see into the field and it appears to be flat and the people are visible, doesn't mean from a different angle with different things in between them, like this vehicle that was stopped, means anything. The evidence in this case shows that, and she doesn't know where Cedric Norris is, and the law enforcement officers described his movements, and ultimately he ended up right behind her. I think it would be unreasonable to assume that once he started moving that he didn't go right for her. And if he's going right for her, it's completely reasonable that the police officers, including Trooper Reeves, are firing at him. He's an active shooter who has already attempted to shoot the law enforcement officers on the scene. Mrs. Huff was inadvertently hit. It was accidental.
Let me know.
Evidence.
Would it be unreasonable for a jury to draw this inference from what happened? Someone had been killed at a bank. There's a very dangerous person in this vehicle. They do not hear anything about there being a hostage. They look and there's another person there and they say, bad person, Confederate, bang, bang. And don't really pay much attention to whether hands are up or not. Maybe your hands aren't up as high as they should be. But why wouldn't that be a perfectly reasonable inference from this testimony, from this evidence? And if that's a reasonable inference, wouldn't that inference make your client liable? Shooting someone with their hands up?
I don't agree that would be a reasonable inference under the facts of this case. I think the facts of this case, the one that is before the court and that there's a record on, don't include that in the absence of some evidence of where Mr. Norris was, which is only provided by the law enforcement officers, the vehicle, and a perspective from Trooper Reeves' point or vantage point, and not from a different direction and a different angle and an entirely different, that it wouldn't be reasonable. I mean, you're.
It would be unreasonable to think that Reeves saw her.
I'm sorry, Your Honor.
It would be unreasonable to infer that Reeves saw the plaintiff?
Based on the record before this court that the appellant presented, yes.
Really? Okay.
Only if you ignore all the other evidence.
Well, no, I think the evidence supports the contention that he didn't see her, that it was completely reasonable that he didn't see her because she's moving and away from him, one, behind the vehicle, and then into a field, through a bar ditch, and then into a field. And Trooper Reeves is some distance down the road away from her, and she's moving away from him. He's also, as the evidence clearly shows, returning fire as he exits his vehicle, seeking cover, then firing more rounds, ducking down behind his vehicle.
Well, see, there's your problem, though, because you're just not giving other portions, which is she runs the other way. She gets out of the car the other direction. Now, I agree with you that he probably, if he were thinking, would want to use her as a shield. But she runs away. You say he's shooting, and she sure doesn't report, and I heard the gunshots right next to me. In other words, that Norris is standing next to her, nor does she ever see him in front of her. And the first time that she even is thinking about Norris is after she has been shot and she's on the ground. Then she says, I sensed that he was behind me, which inference, he saw her on the ground, ran over behind her and used her for cover. If a jury were to come back and find that's what happened, I don't think we would reverse for a lack of sufficient evidence. Is that what you're saying we should do?
Pardon me, Your Honor?
Well, if the jury found all of that and just relied on common sense as far as what happened that day and came back with a verdict, then would you appeal and say that verdict can't stand because there's insufficient evidence?
A verdict in favor of the appellant or Ms. Huff in this instance?
Of course.
Well, I on those limited facts, I don't know what I would do, Your Honor. Ultimately, the facts that exist now on this record establish that Trooper Reeves' statement that he never saw her is unrebutted. Irrespective, the two things can both happen. Pardon me, Your Honor?
Except by the plaintiff who said, I stood there with my hands up and he
well,
shot.
Your Honor, but simply being somewhere where you have your hands up doesn't mean.
You keep saying that didn't happen. It did happen.
Okay, I'm accepting that she's standing at some point in the field with her hands up. That fact
well, that's a different question now.
What is disputed is whether or not Trooper Reeves saw her standing there with her hands up.
Well, first, Trooper Reeves, we're on summary judgment. We're on summary judgment.
Yes,
and Trooper Reeves' word is not gospel. It's one account. Does he then testify, Norris was standing right next to this lady and my hand was a little shaky and I shot, so I might have hit her accidentally? There's nothing like that in the record.
No, there's not. He never saw her. I mean, that he didn't see her. That's his testimony. And
well, he doesn't put Norris right next to her at the time that she's shot, right?
Well, he's following Norris and tracking Norris and firing at Norris. Norris does end up right next to her. He ends up right next to her at the point that she's behind him.
Or she's on the ground.
Behind her, rather. And what we don't have, and what the plaintiff didn't present to the trial court, and hasn't presented here, is any evidence from Trooper Reeves' perspective. And your honors were correct in that it didn't work out. I have not given any time to Mr. Poe, and I'll defer right now so that he can make whatever finishing touch he wants to make.
I don't think that's necessary.
All right.
If you want 20 seconds, Mr. Poe, I guess I'll give you 20 seconds. But I think your position was probably well vetted in the questioning of Mr. Engel. Go ahead. You need to.
You're muted.
Yeah.
Judge Hartz, just two things. The manner of Mr. Norris and Ms. Huff being when they were laying down, they were in a T shape. So Mr. Hall had a direct shot at the side based on how they were configured on the ground, had a direct shot. And he did testify that he knew not to shoot at somebody who was not a threat, did not believe her to be a threat. And then, Your Honor, if I can, your standard that you asked Mr. Engel about on a supervisory liability policy or training case is whether the Sheriff Ledbetter knew of and disregard a substantial risk of harm due to an alleged inadequate policy or inadequate training. And they had policies in this case. There's no notice to the sheriff, no evidence of any notice that the policies were inadequate to protect, especially going along with Mr. Hall's training and testimony when he said he knew he couldn't shoot somebody who was not a threat.
Thank you. Mr. Engel, you have a little time left. It was just under 2 minutes. Do you wish to use any of that time? You're muted still. You're still muted, Mr. Engel. Can't hear you. Okay, there we go.
Sorry about that. Counsel keeps saying that there's no evidence that Trooper Reeves could see Julie Huff. Cedric Norris, who he claims he did see the entire time, was shot 3 times. Julie Huff was shot, who he claims he couldn't see, was shot 10 times. At least 4 of those shots came from Trooper Reeves, based on the sheer numbers of bullets alone. So the woman that he claims he couldn't see, he shot her at least 4 times. And the man he says he did see the entire thing, he only shot 3 times. That alone, as well as all the other evidence, he saw Julie Huff the entire time and he shot her. That's all.
Thank you, counsel. I also would like to give a shout out to one of the Appellee's attorneys, I can't remember which one, for knowing the difference between lie and lay. That distinction has pretty much disappeared, but one of you knows it. I guess Mr. Poe is smiling. Thank you very much, counsel. Case is submitted. Counsel are excused and will be in recess until 9 tomorrow morning.
Court is in recess.